Hello friends, you're tuned in to the Supreme Court Historian YouTube channel. This is going to be our first ever tax law decision and also our collection's first ever intellectual property law decision. This is the Commissioner of Income Tax Bombay versus Finlay Mills Limited, decided by the Supreme Court on the 1st of October 1951. The case revolves around three concepts: the concept of a trademark and what is its registration, what does it amount to, and the concepts of revenue expenditure and capital expenditure. So let's discuss these three concepts at the outset in a very brief manner by giving illustrations. So the first thing that we will discuss is the concept of a trademark, which is basically what we call a brand name, for example. So as an illustration, let's take this channel, Supreme Court Historian. I have named this channel Supreme Court Historian, and I'm uploading videos on this particular subject under this channel heading. What if somebody else creates that same name and starts uploading videos as well? Do I have any legal remedy against this other person? The remedy is, if I had already registered my channel name as a trademark, then nobody else can use it. So I can prevent other people from using my brand name, and to do that I have to register my channel name as a trademark. In order to register as a trademark, I obviously have to pay the government some sort of fee, some sort of expense has to be incurred by me. Now, what does this income fall under when I file my tax returns? Is it a revenue expenditure or is it a capital expenditure? I am assuming now that I am a company. A company incurs certain operational expenses periodically, such as paying salaries to its employees or maintaining its offices and premises, stuff like that. All of that falls under revenue expenditure. On the other hand, larger expenses which are not periodical, which are what we call once and for all, those expenses which result in the generation or creation of an asset, such as buying land or building a factory or buying machinery, all of these are assets belonging to the company, and the expenses incurred in creating these assets, they fall under capital expenditure. And it is these three concepts around which CIT Bombay versus Finlay Mills revolves. The facts are as follows: 1943-44 and 1944-45 assessment years, the tax returns filed by Finlay Mills for these two assessment years contained certain entries under revenue expenditure. These entries related to the expenses that Finlay Mills had paid in order to register their trademarks. These expenses had been incurred by way of the fee that they paid to the patents office in order to create these trademarks. And according to Finlay Mills, this money that they spent should fall under revenue expenditure. The tax department disagreed. According to the interpretation of the income tax department, the money paid for registering your trademarks should fall under capital expenditure. According to the tax department, represented in this situation by the Commissioner of Income Tax Bombay, according to them, the registering of a trademark results in the creation of an asset. According to them, a trademark is basically an asset. According to Finlay Mills, the trademark is just your regular operating expense. So this particular question had to be decided by obviously the judicial authorities, which happened to be in income tax cases. The jurisdiction was held by the Income Tax Tribunal, which found in favor of Finlay Mills. The Income Tax Tribunal said that indeed trademark registration fees fall under revenue expenditure. For this purpose, for arriving at this decision, the Income Tax Tribunal had relied on a Bombay High Court judgment that had come on the 2nd of September 1946, CIT Bombay versus Century Spinning and Weaving. Century Spinning and Weaving was another textile mill in Bombay, just like Finlay Mills was a textile mills in Bombay. Obviously, the trademarks that both of them had registered must have been the name of the fabric that they had been manufacturing, something like Raymond or Vimal or something like that. I'm not very well informed in these matters. So anyway, the CIT Bombay versus Century Spinning and Weaving was relied upon by the Income Tax Tribunal, but CIT Bombay wanted to overturn this decision. So they asked the Income Tax Tribunal to pose this question to the Bombay High Court again. Basically, they wanted the Bombay High Court to overturn its own decision that it had given in the Century Spinning and Weaving case. On 23rd March 1949, the Bombay High Court refused to overturn and instead reaffirmed its decision in the Century Spinning and Weaving case, thus upholding the Income Tax Tribunal's decision as well. The Bombay High Court basically once again reiterated that trademark registration fees fall under revenue expenditure, and the CIT Bombay decided to appeal this to the Supreme Court. Obviously, if you have to overturn that decision, it has to go to the Supreme Court. The case was heard by a three-judge bench: Chief Justice Hiralal Kania and Justices Meherchand Mahajan and N. Chandrasekhar Iyer. The bench basically had to then figure out the import of these three concepts. What is really a trademark and what does its registration amount to? What is capital expenditure and how does it differ from revenue expenditure? The CIT was represented by the Attorney General M.C. Setalvad, and he made this argument. He relied on an old House of Lords judgment, British Insulated and Helsby Cables versus Atherton. Atherton happened to be the name of the income tax commissioner in Britain, in whatever part of Britain this was being contested. The House of Lords laid down the principles of differentiating between capital expenditure and revenue expenditure. And to quote Lord Cave's pretty immortal words, when an expenditure is made not only once and for all, but with a view to bringing into existence an asset or an advantage for the enduring benefit of the trade, there is very good reason for treating such an expenditure as properly attributable not to revenue but to capital. So let's break this lengthy and informative sentence into bullet points. The first point is basically, when you try to differentiate, how will you define a particular expenditure as expenditure? According to Lord Cave, it should fulfill the following criteria. First of all, it should be an expenditure that is made once and for all. It should not be a recurring, perpetual expenditure that you have to make, like salary, for example, right? Salary quite clearly falls under revenue expenditure or operating expenses and not capital expenditure. So this should be the kind of expense you incur only once and once and for all. Like you buy that particular piece of land once, you don't have to keep on buying that land over and over again. You build that particular factory once and for all. So these kind of expenses have to be capital expenditure, but that is just one of the criteria. The next criterion, according to Lord Cave, is that this expenditure should be made with a view to bringing into existence an asset or an advantage. An asset should be created by incurring this particular expense. Thirdly, that asset or advantage should be for the enduring benefit of the trade. The crucial term there is enduring benefit, not just one-time benefit or sometime benefit or intermittent benefit, enduring, perpetual benefit of the trade. If these three criteria are met, then according to Lord Cave, the expenditure should be should be attributed to the capital expenditure bucket and not to the revenue expenditure. So let's try and understand which of these criteria are met by the trademark registration fees. Basically, the CIT was arguing that passing of the Trademarks Act of 1940 was the action which created an enduring benefit for that particular trade. What they were saying is that had there been no Trademark Act passed at all, and Finlay Mills had been using their brand name, let's say Finlay Fine Cloth or something like that, then that brand name had existed even before the Trademarks Act had been passed, but it has been converted into an enduring asset by the passage of the Trademarks Act. It's a very abstract argument, and it is, well, to be honest, it is a very artificial argument. What the CIT's legal team, led by Mr. M.C. Setalwad, was arguing was that just as a machinery may attain higher value by the implementation of and causes greater productive capacity, similarly, even if you had been using your brand name before the Trademarks Act, because the Trademarks Act was passed, this brand name of yours is now perpetual, and therefore it is in the nature of capital expenditure, and which is why we need to spend a moment to understand what is trademark registration, what really happens when you register your trademark, what exactly is added to your trade, to your business, what exactly do you gain. And this was explained very nicely in the judgment by Chief Justice Kanya. The Chief Justice tries to make us realize that registration of a trademark merely absolves the owner from the obligation to prove the ownership of the trademark. As I discussed at the start of the video, if I had registered my Supreme Court Historian channel name, if I had taken a trademark, obtained a trademark for it, then in the case of a dispute, I would not have to prove that I own that particular name, Supreme Court Historian. Right? It is proved as soon as I produce the registration certificate, as soon as I show the registration certificate. If I have not registered Supreme Court Historian as a trademark, then I will have to bring evidence to the court to prove that it was I who came up with that particular name and I have been using it from so and so date. This second person has came in later in the picture and has been pirating my particular mark. So, to read out the words from the judgment, registration absolves the owner from obligation to prove ownership of the trademark, which is prima facie proved on production of registration certificate, saving the owner the trouble of leading evidence to prove title to the trademark. Registration is thus merely a cheaper and more direct remedy against infringers. Cancel the registration and the owner still has his right enforceable at common law to restrain the piracy of his trademark. The Chief Justice is basically explaining that registering a trademark does not create the asset. The asset was created as soon as the mark, as soon as the brand name was created. So as soon as I named this channel Supreme Court Historian, that is when the asset was created. Now whatever goodwill accumulates to that particular asset, it doesn't go away if I don't register it as a trademark. What happens when I register it? It only makes it easier for me to prove that I own that particular trademark. That is all. It just makes it easier and cheaper to make that particular argument, to prove that particular ownership. The Finlay Mills legal team also had another ace up their sleeve. This was another House of Lords decision, Southern versus Borax Consolidated. Southern, once again, believe it or not, is the name of the income tax inspector, the income tax commissioner rather, in that particular case. And the concept around which Southern versus Borax Consolidated was decided was about maintenance, where a sum of money is laid out for the acquisition or the improvement of a fixed capital asset. It is attributable to capital. That is fine. Once you incur something for acquiring an asset, that is fine. That is quite clearly capital expenditure. But if no alteration is made in the fixed capital asset by the payment, then it is properly attributable to revenue, being in the substance a matter of maintenance, the maintenance of the capital structure or the capital asset of the company. So basically, expenditure incurred by a company in defending, for example, the title to property. If there is a dispute about a particular land that I have purchased, that my company has purchased, and the company is in dispute with somebody else, they say that they own that particular piece of land. So we go to court and we incur certain expenditures, we pay our lawyers and the court fees, and eventually whatever the court decides, let's say in our favor. Then what happens to the money that we have spent in proving that that particular asset is owned by us. That money, should it go under revenue expenditure or capital expenditure? Obviously it should go in revenue expenditure, is what Southern versus Borax Consolidated held, because the asset was not created by winning that particular case. The asset you had already been in possession of, you already had its title, the court merely affirmed it. And that is what happens in the case of a trademark, is what Finlay Mills argued, is what the Supreme Court agreed. The Supreme Court therefore ruled in favor of Finlay Mills, upheld the judgment of the Bombay High Court and of the Income Tax Tribunal. Before that, trademark registration does not result in creation of a capital asset of an enduring nature. Further evidence of that, the validity of trademark was only 7 years under the 1940 Act. Now it is 10 years since the passage of the 1999 Trademark Act. There was another act in 1958 which came between these two. So the 1940 Act was repealed, and that repealing act was further repealed in 1999, and that is the Trademark Act in force right now, which gives us the validity of trademarks in India, which is 10 years, not of an enduring nature. So the expenses you pay for acquiring a trademark, or rather for registering a trademark, I should not use the word acquiring, the expenses incurred for registering a trademark are not in the nature of a once and for all expenditure. It's not a once and for all expense. You have to make that expense every 10 years. Therefore, another reason for not calling it capital expenditure, but instead revenue expenditure. Secondly, registration fee in the nature of is in the nature of asset maintenance expenditure. Hence, it is capital expenditure, but is instead revenue expenditure, and it is therefore deductible under Section 10 of the Indian Income Tax Act of 1922, another act which has since been repealed by the 1961 Income Tax Act. Anyway, that is for another day. Today then we rest knowing that the Supreme Court agrees that the registration of a trademark, the expenses incurred for that, fall under revenue expenditure, and therefore you can deduct that from your profit at the end of the financial year. That is CIT Bombay versus Finlay Mills. I apologize for the disturbances. It's been quite a day today. Thanks for listening. See you again next time. Bye-bye.